Your Excellencies, judges and ambassadors, dear guests, I also a special word of welcome for the representative from the municipality of The Hague, Rob Schuurmans. The municipality supports the annual ASSER lectures, and of course, especially our guest of honor and speaker, Martti Koskenniemi. It is a great pleasure to see so many judges, ambassadors, civil servants, teachers, researchers, and students attending this fourth T.M.C. ASSER lecture. Bringing you together around a distinguished speaker with a subject that fosters a sense of direction in our work is the purpose of this annual lecture. Tobias Asser, the law professor at the University of Amsterdam, took up the mission of his time to promote multilateral initiatives in international law as a diplomat and one of the initiators of international journals and conferences. Having started in the field of international commerce and international private law, he aspired to promote trust in international relations in general. This is the way in which he viewed his mission for his time. In our work at the ASSER Institute, we take inspiration from Asser's idea of cultivating trust and respect through law and legal institutions, and to examine what it could mean in our area of expertise today. Martti Koskenniemi demonstrated in one of his seminal works on international law as the gentle civilizer of nations, which interests and preconceptions defined the views of the men of 1873, one of whom was Tobias Asser. Honoring Asser's legacy does not mean that we would want to get stuck with it. The task remains to discover how international and European law in the divisions and threats of this century might contribute to more humane, trustful relations. And that requires to be aware once more of the events and views that work in the opposite direction. With a speaker like Martti Koskenniemi, we will certainly be inspired and stimulated to recognize our mission in our time. Our speaker will now be introduced by my colleague in the board of the ASSER Institute and at the University of Amsterdam, Janne Nijman, Professor of History and Theory of International Law. Thank you for being with us.
Great. Your Excellencies, distinguished guests, dear colleagues and friends, it is my great honor and pleasure to introduce to you this afternoon a colleague and great friend, Professor Martti Koskenniemi. And of course, it's impossible to do justice to Martti's work in the course of a few minutes. Professor Koskenniemi has, I dare to say, redefined the discipline of international law in the past 30 years. So in class, I simply introduce Martti as a true rock star of international law. And then we discuss how reading Martti's work is often a life-changing experience. His books are intellectually rich and powerful. They're highly instructive and profoundly engaging. Professor Koskenniemi caused a shockwave in the international legal discipline with his 1989 book, From Apology to Utopia, The Structure of International Legal Argument. I remember how in the mid-1990s, I was at Leiden University at the time, this shockwave rippled through Dutch academic circles and through the Hague high grounds of international legal institutions. The way Martti critically deconstructed international law and legal argumentation gave some a sense of liberation. With others, it caused deep resentment. From Apology to Utopia, or FATU, as the book is also called, is an intellectual tour de force, bringing structuralism to international law. Structural analysis looks for the deep structure that is generally hidden, yet has a stake in the production of the visible social phenomena around us. By bringing this type of analysis to international law, Martti challenged how mainstream academics were thinking and writing about international law. But From a Polity to Utopia is not a work of international legal theory. Koskenniemi is theorizing to understand international law practice, a practice he has experienced firsthand as a Finnish diplomat and legal advisor. With his work, he challenged the academic discipline of international law to be honest about international law. We had to stop living the fairy tale that more international law would bring us automatically more justice, less war. Martti's work showed that law is indeterminate. It is language. It is interpretation. As such, it is strategy and tactics. There is politics in law. And from that, I would add, it follows that international lawyers have a responsibility. Koskenniemi's project is not merely descriptive. It is also normative in its ambition. For if law doesn't produce substantive positions or outcomes, but rather justifies them, then when we analyze a legal argument in a judgment or when a rule is proposed, the questions should be who wins, who loses. These are political questions. They open up a space for critical, emancipatory thinking. A thinking that fits well with the intuitions of many students and international lawyers alike. It still strikes a chord for me. Koskenniemi ascribes to international law a place in this world beyond mere technical use by experts and bureaucracies. This is a place which he seeks to understand also through history. So in his next book, The Gentle Civilizer of Nations, The Rise and Fall of International Law, 1870-1960, Koskenniemi studied the man of 1873. And as Ernst just mentioned, Tobias Asser, who gave our institute his name, is one of these men. Where Koskenniemi took a structuralist approach to the international legal argumentations of international jurists in From Apology to Utopia, he explored the lives and arguments of many of these jurists contextually in The Gentle Civilizer. Now, although Martti and I share a great interest in the intellectual history of international law, and I know Martti is working and preparing another, what I'm sure will be groundbreaking book in this field, I've urged Martti to speak today his mind about international law in our times, our confusing or even disconcerting times. Today's lecture is an annual event within the context of our research program called International European Law as a Source of Trust in a Hyper-Connected World. And since the launch of our research program in 2015, questions of trust and trustworthiness have only become more pertinent. For how to understand and address the Brexit, the Trump administration, and growing alt-right. How to cope with the anti-globalist populists. How to deal with the backlash against international law and its institutions. How can international law be relevant amidst these global developments? Where do we stand after 20 years of fragmentation, deformalization, and the formation of global elites in international law, to put it in Martti Koskenniemi's vocabulary? Martti was critical of what he calls the managerial turn, with which international law has become something technocratic, a world of experts and expertise. His critique came with a call for repoliticization. One could argue that with the current political discussions on the EU and Brexit, on TTIP and on the international law of foreign investment, a repoliticization of international legal discourse at arrivé près de chez nous. If international law is inherently political in nature, it requires an openness about the interests, commitments, and values that come with the use of the language of international law. I understand Martti Koskenniemi's work also as a call upon international lawyers in that respect, a call to be conscious about our responsibility for the substantive outcomes when working with the law. Ultimately, Koskenniemi demands an authentic commitment to look for justice, situational justice, to keep asking who wins, who loses. With the annual T.M.C. lecture here in The Hague, we aim for an afternoon of reflection and discussion. Reflection on important global issues and on how these challenge international law. We do so from a profound commitment to issues of social justice and from the conviction that we need to bring critical thinking to power, right here in the Peace Palace, in the City of Justice and Peace. For this year, in these times, there is no better speaker to guide us in this critical reflection than Martti Koskenniemi. Martti Koskenniemi is Professor of International Law and Director of the Eric Castrin Institute in International Law and Human Rights at the University of Helsinki. He is also Hauser Global Professor of Law at New York University School of Law. Professor Koskenniemi's list of honors, prizes, honorary doctorates is very long. He serves the global academic community with visiting professorships and by advising numerous academic journals. Here in The Hague, it's good to mention that Martti worked for the Finnish Ministry for Foreign Affairs from 1878 till 1994. He was a member of the UN International Law Commission from 2002 to 2006, and he has been involved in various cases before the International Court of Justice. What I would like to stress, and here I speak also from personal experience, is how supportive Martti is for younger researchers and their research projects. The PhD masterclass, which Professor Koskenniemi is generous enough to give at our institute tomorrow, is another case in point. For the annual ASSA lecture, we always look for speakers who are more than expert international lawyers. We look for public intellectuals who dare to address the questions of our times. So please join me in providing a warm welcome to today's speaker, Martti Koskenniemi.
Thanks. Thank you so much, Janne, for that kind introduction. I'm really pleased, of course, to be back in the Peace Palace, back at the Hague Academy of International Law, and to see so many students, old colleagues, young colleagues, and to imbibe the atmosphere of the Asser Institute that nowadays has become one of the high points of critical scrutiny of international law and international relations in the world. Okay, so let's see if we get this going. So, as has already been mentioned in a previous book called The Gentle Civilizer, I analyzed the starting point of international law as a professional discipline, and of course Tobias Asser is part of that story. The subtitle of the book, however, is The Rise and Fall of International Law, and I haven't had too much experience yet in trying to talk about that latter aspect, the 1960s and the fall, so I will try to do that with you tonight. Tobias Asser, together with his colleagues, Gustave Rollin-Jacquemin from Belgium, Gustave Meunier from Switzerland, and John Westlake in Cambridge, England, created international law as a project. It was a project to bring liberal legislation in Europe and to civilize the colonies. In an article in 1880, published in the professional journal of the Institut de droit international, the Revue de droit international et de la législation comparée, Tobias Asser, through a review of the past few years, 7 years since the establishment of the Institute, what had happened between 1873 and 1880. And he expressed a disappointment. He said what these men had encountered was the accusation of being hopeless utopians. They had tried to do the best, he explained, to bring to Europe what he and his colleagues called l'esprit d'internationalité. What would that esprit contain? Well, he explained this had something to do with a more enlightened patriotism. That expression struck with me, a more enlightened patriotism. That to me suggests that more was at issue in the project of the men of 1873 than utopian thinking about world government and all that. To take patriotism as it existed in Europe in the 1880s and to tweak it a little bit in a more enlightened direction. Well, of course, it's a long story. And one of the outcomes of that story is this institution, which is built on two principles which I lay out here. One of them being the sovereign equality of states. In the current backlash against l'esprit d'internationalité today, there hasn't been, so that I've seen, any significant well-worked out criticism of the United Nations. And why should there be? Why should there be? Because the UN is built on patriotism and statehood. Statehood exists nowhere as clearly as in that great hall. There's no place where a state can feel itself as much a state as when it steps up in that hall and speaks to the audience. Here I am, a state, and only a state, a sovereign equal with others. When I entered the profession sometime in the late Middle Ages, in the 1970s, it was often the case that state referred to Article 2.7 of the Charter, the reservation of domestic jurisdiction, but somehow in the course of the decades, it became politically problematic. And only some states, and maybe there are diplomats from those states here, still dared to make that reference. Certainly, it was held to be slightly impolite. Nowadays, of course, it's a part of the Charter provision, and one maybe hears that more. So I'd say there's no reason for the United Nations specifically to be targeted by nationalism, xenophobia, by statist activism. The state is there. Nevertheless, we witness something out there. There was this plebiscite, this referendum last week in Switzerland, in which a group of Swiss citizens from the right, of course, thought that they should get rid of foreign judges. They should get rid of la tutelle étrangère. Mark in this ad the age and gender of the disappointed Swiss. So one cannot deny that there is something is moving out there. And what I want to suggest to you is to take this movement seriously. But to take it seriously so as to make a clear distinction between two aspects of the movement. A legitimate protest against something out there in the world, something that we really need to understand better than we do today. And a far-right manipulation of that legitimate feeling. how to engage in a discourse with the legitimate protesters against globalization, maybe also against foreign judges and all that, while at the same time avoiding getting trapped into the far-right trap that's being set to us by the manipulators of the day. I want to address this theme by reference to cynicism. By cynicism, I mean a very specific phenomenon. I mean a decalage or a gap, as I will detail further, a gap between expectations that today has created and the experience of many people. When the gap between the expectation given to people and the experience they have of their lives becomes too great and is repeated over and over and over again, then that expectation is no longer there, but its place is taken by cynicism. I want to move now to the standard, dare I say, liberal centrist understanding of the backlash and the protest movement. And who better to display that centrist understanding than one of the great heroes of our time, Mark Zuckerberg. So in the spring of 2016, and many of you may have read this, he laid out a manifesto, Building Global Community, on Facebook, of course. And there he noted with some concern that when Facebook began, the idea of, as he said, bringing us closer together and building a global community was not controversial in the least. But now what he sees is a withdrawal from global connection. He suggests that many people feel they've been left behind. And he suggests that what now should be done is to build a global community that works for all of us. I think this is wrong. Left behind? No. There is not the situation where we can think of globalization, modernity, and all of that as a kind of a train ride, where the tracks have been set, we are all on the train, but at one point we notice, well, some people were left standing there in the previous station, so we must back up and get them on the same train. No, it's not like that. There's nobody in that station. There's no train. There are no tracks already made. So the experience of the protesters is not that, if only we were on that train as well. They hate the idea of the train. They hate the people on the train. They wouldn't step on that train even if they were paid for it, as we now see. What they feel is they are defeated, not left behind, defeated, meaning somebody else has won because they have lost. This is a famous, the elephant curve. I don't go into any details. The curve by Branko Milanovic has been shown everywhere. It tells the story of the growth of income of various groups of people between 1988 and 2008. It's an abbreviation of what we could call the experience of the 1990s. The experience of the 1990s has been very different for four groups of people. On the one hand, there are those whose income has increased tremendously. The middle classes in the emerging economies, China and India especially, and then the richest of the rich, the 0.1%. Whereas the income of two groups has not increased at all, namely the poorest of the poor and then the middle classes, especially the lower middle classes of the developed world. The liberal understanding of this is that the backlash the protest movement is a social pathology. And we should therefore treat it as a kind of a sickness which should be cured by reforming our institutions. Let's have more reform. Well, no, nobody wants reform. And even if you try, you'll fail. Why? Well, what's wrong with the institutions? You can say, if you start here, well, it's too bureaucratic. And the bureaucracy enshrines elite privilege. We have to get rid of all of that. And how do you get rid of all of that? Well, by suggesting privileged policymaking. Principled policymaking. Talk about the great objectives to be achieved, the values that we all share. Well, no, that's just talk. It's obfuscation. So, but how do you get away from just talk and obfuscation? By institutional action, by setting up another committee to reform whatever it is that you want to reform. But actually, that's bureaucracy and so on. So the one thing about the protest from the far right that we see today is that they're not interested in reform. They're not interested in reform of institutions which already are illegitimate. And to participate in a reform is to accept that maybe there could be something to be done with this. But these are the adversaries' institution. Remember, we are the vanquished. Why would we participate in your institutions that you have imposed on us? You can do nothing because you're trapped in So anger. There's undoubtedly much anger. And is the anger justified? Well, mostly no. If you look at the middle class's income in, let's say, Poland or Hungary, to take just two random examples, or the United States, or indeed the Brexit areas in Britain, by no global standard are these people deprived and poor. But they are angry, and they want to crush the adversary because that is how they feel, that they have an adversary who has defeated them. The adversary is illegitimate. And so it doesn't matter if the Rust Belt suffers from Trump. It doesn't matter if, as the chief of the English bank explained, that in the case of a no-accord Brexit, over 9%, the British national income will sink over 9% in some period. It doesn't matter because it's not a social pathology. It's not something to be cured by more economic or other reform. It's about anxiety. It's not justified anger, it's about anxiety. It's more specifically anxiety about the loss of white male privilege. The loss of white male privilege. It's an anger about the emergence of a new cultural and political hierarchy, where we, these people think, are now at the bottom. There used to be a time when white males, whatever their income, whatever their position, our position, we could always say, well, however bad we are, at least we are not like those people. No longer. You are at the bottom. And so what do? Take back control, damn it. Taking back control, that slogan is a really clear slogan, the significance of which is we have to now re-establish the hierarchy that used to exist. The hierarchy where whatever our income level, we were still in control, that there were no minorities, no women, no Jewish philanthropists who were stepping on our toes on a daily basis. So that's the analysis. It's not about economic deprivation, it's anxiety on cultural hierarchy, the loss of a cultural hierarchical position, and a wish to re-establish it. It's reactionary in the very specific sense of that word. It looks back to a moment. Well, what moment? Well, before the moment that the structure of international law changed. Wolfgang Friedman's wonderful book, The Changing Structure of International Law, was published in 1964. It was an end of era book. It was also an opening of an era book. It is the book that was in my mind when I titled my previous book on the gentle civilizer of nations as The Rise and Fall of International Law. Now, I don't mean to say, on the contrary at all, that Wolfgang Friedman would signify the fall of international law. No, he showed that what we had thought of as international law earlier on could no longer be that. Times are a-changing, as another hero from the 60s used to sing. And in this wonderfully prescient book, which I urge you, try to find a copy and read it. It's remarkable. So he suggests that we are moving from an international law of coexistence to an international law of cooperation, where we are gradually being united by the emergence of various specialized fields of the law. Fields such as law and technology, fields such as development law. He was particularly concerned over what he called the unprivileged nations and a new law of development that would deal with problems that they faced. He wanted specialists in the law of the sea. He wanted specialists in international trade law. He thought that whatever had existed during the Cold War was old hat and could no longer manage the problems of a uniting world. In the 60s, we used expressions such as spaceship Earth, for example, to highlight how indeed we are united and also to underline the technology that was needed, the technological approach that was needed, a spaceship, in order to fix what needed to be fixed. And he suggested that there was a new morality emerging. Only gradually and with small steps, this was the morality of human rights. In Europe, regional steps have been taken, and Wolfgang Friedman suggested that maybe the right way to go is the regional way. But he made it clear that the end should be a global culture of human rights. Fast forward to the 1990s, the problematic decade, the 1990s. So two experiences emerged in the 1990s. One was the set of problems of legal knowledge. International law, as international lawyers, and I have to be careful not to dwell on this too long, international lawyers started to deal with fragmentation. That everything was fragmented. All that solid melts into air. I mean, they didn't cite Marx, but I did. That what had existed as a solid core of the law had been breaking up into these incommensurable worlds of trade law, of human rights law, of investment law, of sports law, of humanitarian law, etc., in an unending way. And not only that, they required very highly sophisticated technical knowledge to be managed, because they were regimes of knowledge that looked towards the management of problems that were felt to be global. Therefore, they also had an ethos, every one of them. An ethos that looked for the optimal solution of the problems of the particular regime, whatever the regime, a security regime, a human rights regime, an environmental regime, and a trade regime, etc. But which is the right regime? Bring to the room a human rights lawyer and a law and security expert. Bring to the room a trade expert and an environmental law expert. And you know they live in different worlds. And you know that the most important political decisions all of a sudden start to be the ones that allocate jurisdiction. Jurisdiction either to the trade law person, or to the environment law person, to the security law person, or to the human rights law person. How do you decide? Where is the constitution? But there is no constitution. It's a struggle out there. So problems of knowledge. What do we know about this spaceship Earth? What are its real problems? When a human rights person opens a window in the morning and looks into the world, she sees human rights problems all over the place. And she knows that human rights will have to be much more aggressively employed on that world. Same window, it's a trade lawyer now opening it. And it's problems of free trade, so subsidies all over the place. You know, we have to fix it. Development law person, you know how it goes. So it's not that we know about the world. We know the world in too many ways. Too many knowledges. Friedman, in his book, suggested that there were, on the one hand, problems of knowledge, which technical regimes have to deal with, but that there were also problems of morality, a universal morality. And lo and behold, in the 1990s, we have human rights. Where did human rights come from? Well, human rights emerged in the 1970s, as Sam Moyne has explained it, but I have a slightly different explanation. They did arise in the 1970s in response to the experience of deformalization. As Max Weber had explained, late modern law is necessarily a law that's deformalized. In traditional societies, we can govern those societies through rules. Rules that apply to every single member of those traditional societies in a similar way, because the outlook of those people is very similar. They all wake up 5 o'clock in the morning, they go to the fields, they have their lunch, on Sundays they go to church. Tradition is that. But tradition is broken down. Some people go to the fields, other people go to the factories. In the factory, somebody is, as Durkheim explained, somebody is a shoemaker, and the other person is the owner of the factory that makes those shoes. There's nothing that joins the lives of these two persons in common. So you can't regulate their lives by single rules. You have to differentiate. So you insert in legislation rules about reasonableness, about good faith, about best practices, and so on. What that creates, however, is the possibility, the endless possibility of administrative abuse. You are now totally at the mercy of somebody in a court, but more likely in an administration, thinking about, what might be a reasonable way to deal with that person. And you don't want that. Why not? Well, imagine this situation. Imagine that your parents, or worse, yourself, have a nice apartment in the center of the city. And that the city officials, who are well-educated managers of city governance, by applying the new regulatory provisions that govern the government of the city, decide that the optimal use of the city's resources would be to move old people from the center of the city to the suburbs, close to hospitals and graveyards and so on. That's the economically optimal solution. That's reasonable, taking everything into account. Now, how do you respond? Now, you respond, of course, I want to stay here, not only that I want, but I have a right to stay here. The right, as Ronald Dworkin taught us, is a trump card. It overrides these managerial calculations by technical legal experts. A right is a right is a right. And there you stay. Oh, that's what you think. But what happened in the 1990s was that when people noticed that, oh, well, that's a really powerful thing to have, a right, then we started to translate our preferences into rights. And in no time at all, every preference, every significant social preference that was there was translated into the right of the preference holder. What happened? Well, all of a sudden, the organs asked to apply human rights, the European Court of Human Rights, or the committees on political and civil and political rights and economic, social and cultural rights, they all started to balance rights. Balance? But what was the situation from which you wanted to get away from when everything was deformalized and people just balanced things against each other? So in the 1990s, everything was a right. And when everything is a right, of course, nothing is a right. So the two phenomena, on the one hand, knowledge breaking up into regimes of knowledge, fighting against each other. And on the other hand, justice breaking up into rights, fighting against each other. How do you choose? And the last suggestion, a slight critique of international law in terms of bad faith. Now, of course, international lawyers are also opening windows and seeing the world. And they see an international world. Well, as a matter of fact, they feel that international lawyers are now needed to solve these problems that are out there. As my friend David Kennedy always says, for a man with a hammer, every problem is a nail. For an international lawyer, every problem is an international law problem, understandably. Who wouldn't be worried about their salary? So there is a bias. So here are two really important 20th century figures. Hirsch Lauterpacht, whom I've quoted sometimes as having written the most important English language book in international of the 20th century, The Function of Law in the International Community, 1933. Lauterpacht was a great opponent of statehood and sovereignty and all that. He was so the function of law is a complete celebration of international law against the arbitrariness of national sovereignty. He went so far in his anti-statist thinking that when he was writing a draft for the opening speeches of Sir Hartley Shawcross in Nuremberg, because he did write many of the Shawcross's speeches, he wrote in the opening speech these lines: "The sanctity of the sovereign state is now arraigned before the law." So for Lauterpacht, the Nuremberg trials were a trial of sovereignty and statehood and all that. When Sir Hartley saw that, we didn't hear that. That's not in the records. And we can easily understand why it wouldn't be. Sir Hartley came from a country that had just tried desperately to defend its sovereignty for the past 5 years or so. As, for instance, my country at the time. The call to be against sovereignty doesn't sound often very powerful, nor did it sound for Sir Hirsch Lauterpacht, because after he had written the speeches for Shawcross in Nuremberg, he traveled to New York, where the Secretary General of the UN assigned him to write the first work program of the International Law Commission, which he did. But because that was just a piece of cake for him to do, he was also assigned to work for the Jewish Agency. The Jewish Agency, which in 1946, 1948 represented the diaspora of the Jews in New York. And in that capacity, he participated in the drafting of the Declaration of Independence of Israel. So how does a cosmopolitan hero whose life's work is condemning sovereignty, how is that person now establishing the state of Israel? Now, of course, you and me understand that that would be the kind of thing because of the context, because of the way the 20th century was. But why then didn't he openly address that issue? There was another person who did at the time. This was Karl Polanyi, the great Polish economist whose work, The Great Transformation, was published first time in 1944, then as a full edition in 1946. Polanyi, who was also a refugee like Sir Hirsch was, Polanyi in the United States eventually, So in this work, The Great Transformation, he wanted to address the question, how was Nazism possible? Where did fascism receive its energy from? He was an economist. And the great transformation that he discussed in that book was the transformation in the late 19th century into a liberal economy, into a free trade economy. And he addressed the expansion of trade, international trade, with the neologism that we now all know, namely the word disembedding. His argument was that sometimes in the late 19th century and early 20th century, the economy was disembedded from the social. It became international, and when it became international, it lost touch with the world. And he said, you wanted to know what fascism, how fascism rises, there it is. Now that's of course Polanyi. Other people have nuanced the analysis. But I can't forget that analysis. So last spring, I was in New York and I saw this wonderful presentation by the Berliner Schaubühne of Didier Eribon's, he's a French philosopher, Didier Eribon's memoir, Returning to Reims. And the memoir was spoken by the famous German actress Nina Hoss, and she was assigned in this presentation to give a radio show on Eribon's memoir. And at the same time as she was reading from the memoir, she was also reflecting on her own experience. And in the background, there was 20th century history. What was Eribon's point in that book? Eribon had left Reims as a young man because he had broken his relations, especially to his father. Went to Paris, became a world famous philosopher and a gay activist. He never went back to Reims, but then his father died in the 90s, and he was sorry that he hadn't contacted his dad before, and went back. And with his mother, they went through old photographs from the 1950s, in which his father was seen working in an industrial complex where there were lots of workers, many workers from North Africa, many workers from Turkey. And they all were having meetings in common. Those images were images of solidarity, of friendship, and a common purpose. And as Eribon says, my dad and everybody was a communist at that time. The great frustration was, of course, that when he returned to Reims, everybody was voting for Le Pen. What had happened between? Well, we've all have that experience. What happened in the 1990s was one of the great tragedies of the 20th century, the collapse of European social democracy into the third way. Tony Blair, Bill Clinton, you may add other names. Other countries have other names. But all of a sudden, a group of people felt politically homeless. They felt politically homeless because in trying to grasp the center, social democrats joined an unending austerity policy with human rights. So Bill Clinton and Tony Blair are completely at home speaking the language of human rights to their audiences, while speaking the language of cutting the budget to their colleagues in the capital. Austerity and human rights. A failure on the left. I come now closer to international law. I said earlier that cynicism, to which I come in a moment, cynicism is born from the gap between expectation and experience. Investment law is one of the great flourishing technical fields of international law today. How does investment law look upon the world? Here is how it looks upon the world. It says that a government action that has an influence on the profits of the investor might be inequitable or in breach of specific commitments, but it might also be illegal if it's undertaken for political reasons or other improper motives. Political reasons as improper motives for a government to act. We of course understand from where this comes from, and I'm not accusing anybody of bad faith here. This is technocracy at its worst and most abominable. The suggestion is that expertise is objective and even-handed. If that only were true. I come back to that in a second. So I suggest that the sources of cynicism that we nowadays experience in the protests, in the backlash, and that the far right uses for its own purposes are both about rejecting expert knowledge as elite privilege and rejecting politics because parties are no longer representative of anything. I had a dinner some months ago with a Princeton professor, and throughout the dinner the Princeton professor was in a melancholy mode explaining to me why, or trying to find an answer with me in his own head to why it is that nobody talks to him any longer. Why is it that he's being despised? Here's a piece of statistics for you. 58%, more than half, 58% of the Republican voters answer the question, are universities rather more useful or harmful for the United States, by saying they are more harmful than useful. 58%. So knowledge, why would you trust them? So politics, it's none of our business. Or in other words, there is a gap between that which is true and that to which us seems truthful. And also between that which is just politically and that which appears to us as one of the innumerable rights that battles against other rights. Now I suggest to you that Kant had understood this already in 1795. This is what Kant has been saying all the time in the Critique of Pure Reason. You remember, you read it every now and then, you remember two critiques. A critique of knowledge. We can't really know. We just do our best to know. And we don't. And the same applies to the just world. The justice somehow in the nature of it is always to escape us. There is always a gap between what we know and what the truth is, between what we think of as right and where justice lies. But don't worry, said Kant. As long as we are good human beings, we can deal with that. And Kant, ironically or not, deals with that good human being in the famous annex to the Perpetual Peace, 1795. This is the annex where Kant makes the distinction between two personae, two public personae that he calls the political moralist and the moral politician. And he says that the most important thing in our lives when we act in our communities is to distinguish, is not to know what the technically correct response is or what justice is, but to make the distinction between political moralists and moral politicians. Why? What's political moralist? Political moralist is the person who has a language that he or she uses only in order to buttress their own position or privilege, or to get their way in a negotiation. That language may refer to pieces of knowledge, pieces of moral argument, but that's not the point. The point is myself. Instead, the moral politician is embedded in those principles and tries to recenter themselves from their own identity to think about the world, not only from my perspective as a trade lawyer, as a human rights lawyer, as an environmental lawyer, but from the perspective of that other. So this is not surprising, and it's a piece of knowledge that's been around for a long time, but it's forgotten. So on some moods, I said, oh, we just have to politicize all of this. Politics of international law. We just have to be straightforward, and but that was kind of not to the point. Why? Well, because there is no authentic, nice realm of politics where we could just sit down and talk about principles and justice and have a cup of tea and again continue. There is no such realm. I'm sorry, it's romantic. You know, you'd love there to be in that crowd, and you can be in that crowd if you're privileged enough to be in a philosophy department somewhere, but most of us, unfortunately, aren't there, so there isn't an authentic politics. Everything is always already political. And this is the important thing that I want to come across to my colleagues in the True Finn movement, and for you tonight. So we can't access society through some authentic sense of the political, social, democratic, communist, liberal, whatever. They're already fields of knowledge. That's frustrating to some extent, and here is an experience. So this is an experience from the TTIP talks. So one of the big international legal things in the past decade or so has been, as I said, the growth of investment law, but also the diplomatic efforts to get the Transatlantic Partnership Treaty going. Now there's the CETA Treaty, the Canadian-European Treaty, and maybe there will be more treaties in which investment arbitration will play a great role. And the civil society has often been very actively taking a stand on this, which I found delightful. Not only because this means I'm being interviewed all the time, but also because I think here has been a way in which a complex technical problem has been translated into a political set of questions. So something has been politicized, or that's what I thought. So in the course of having been part of these debates, I've sat on countless panel discussions, public panels. And the panels are always organized so that there's a couple of politicians, one in favor of the investment treaty, one against the investment treaty. Then there's one lawyer who is in favor of the investment treaty, typically participating in investment arbitrations. Then there's me, and then there are two economists, one economist on both sides. And the debate invariably goes in the same way. So first the politicians say they blah, 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 and nobody listens very much. Then the international lawyers, the investment lawyer says their thing, and I say my thing. And at that point the audience says, well, you know, apparently international law doesn't have much to say because it says both yes and no. But then the debate always takes one step further when the economists take the floor. And then there's the European Union economist who says that the signing of a CETA treaty will enhance or increase the income of an average European family by £30, which was a number that we once heard. So £30, so thumbs up for it. And then there will be this economist from the slightly leftist think tank who will always be there saying, oh, well, that's just completely nonsense because it makes no difference whatsoever. Because no investors ever look at whether there's arbitration agreement involved or not. Those are not the kinds of bases on which decisions on investment are made. And from that moment, the two economists start to quarrel about the relative merits of their respective models. And if there's still somebody in the audience at that point, they must be wondering, is it the case that we can take a position on this highly political, interesting issue at the heart of globalization only once we have decided on whether this or that model, economic model, is right. So of course, it's always already politicized. It's not the case, as I thought when, and as many of my students have thought, that that you can, by choosing either being a trade law or an investment lawyer or being a human rights lawyer or being something, that solves all the problems, because these fields of knowledge are also always already split against themselves. There's always an orthodox position and a heterodox position, because even if you're an expert, you don't really know. So, I skipped that. There are two ways of going about this thing. I explained to my students and I explained to my friends in the parliament and my political friends how we can deal with it. So politics is always about knowledge, what we know. There is no authentic political out there. So you become an environmentalist, that's a political choice. You become an economist, that's a political choice. But because these regimes are open-ended, you can always try to either join the orthodoxy or join the heterodoxy, whatever, but just be strategically suave about that. Students often come to me saying, hey, Martti, I want to do a PhD with you. And, that's great. So what do you want to do it on? I want to do it on some human rights issue because in the end I want to work for Greenpeace or Amnesty International, etc. So I always think, why would you shoot yourself in the foot in the morning? If you are my kind of a person, why don't you imagine yourself as a man or a woman of power who becomes, who looks for being in a position, in a powerful institution where they can actually influence the world in some sense, instead of just looking towards the nice friendships and the nice cinema and literature that you can have with your friends in the Amnesty section in which you are a member. So that is a question about the seriousness of your political commitment. It is a jungle out there. It involves costs. So you can't be an efficient person changing the world without having knowledge about how the world works. The knowledge will not save you, though, because the knowledge can take you in whatever direction. If you are a person of my kind, then you have a sense of where you want to go. But you want to, and you have to do this through systems of knowledge, in which case you have to make calculations such as these. You enter the World Trade Organization, and tomorrow the World Organization will look like you. Or maybe the other way around. It's a question of personal strength, of course, your stamina, good luck, bad luck, your friends, and also you learn. It's easy to be a critic when you're outside. It's much less easy when you're inside, and not only because you're surrounded by people who are already committed, but because when you start to know people who are already committed, you then notice that, well, actually they've read some books too. And actually their view of the world is much more complex than you thought before you entered that world. And that might then suggest that you should actually be like them because they are admirable in their own way. Or maybe you should just stay outside and throw some rocks into WTO windows. That's a really respectable thing to do, and it's something that gives you a really good sense of satisfaction that lasts for about 5 minutes. Strategic questions. But of course, we can't leave it there. So my students, when I've told them this, that there is no authentic politics, that there is no good bottle of red wine with good friends and the world becomes a more just place by that, they are disappointed. And they say, Martti, is it just tactics and strategy and how do you go about that? I say, and this is something I've learned only recently, that no, that it's also about utopia. It's about utopia in a particular sense. So we as lawyers, as international lawyers, are taught to think of that there are two ways of doing law. Either you are a formalist, you're a rule kind of a person. You think that the law consists of rules and you juggle with the rules. Or then you are a realist, and you think that law is about policies and objectives, and you do that thing. And the formalist-realist distinction or opposition, or the rules and tools opposition, is somehow stultifying. It's somehow petrifying. It doesn't get you anywhere. So I suggest, and I'm in I have good conscience in suggesting this, that law actually is about performance. And when I say this as somebody who's performed a number of times in that building, and the most palpable sense of what it was to be a lawyer was to perform. And I've performed in front of students here, and that's a performance. And in Finnish courts, what is it that we do as lawyers? We perform. Can we perform utopia? So there was a time when at least some people performed utopia. This is Abbé Sieyès at the outset of the French Revolution, 1789, when he suggested to the third estate that they should imagine themselves not as the third estate, but as the universal estate. And it didn't take more than a few weeks that the clerical estate and the noble estate ended their activities and joined the third estate. And what had started as an assembly of estates turned into a national assembly. It's a familiar story. It's a story full of performances, at the heart of which is Abbé Grégoire, there, giving the oath. Who's Abbé Grégoire? Abbé Grégoire is the guy who, before the gentle civilizers in 1795, suggested the adoption of la Déclaration des droits des gens, a declaration of law of nations in which every nation would be sovereign equal to every other nation, and their relationships would be conducted in peace and solidarity. 1795. The French were already in war. And they were starting to win the war, and they were establishing what they called the sister republics. And a few years, and Napoleon was in Egypt. And a few years, and slavery was reinstated in Saint-Domingue. Of course, the reinstatement didn't succeed, and the greatest universal achievement of the revolution was the independence of Haiti. Universal as a performance, but also peace as a performance. One of the 18th century figures with whom I've spent a lot of time recently was Abbé de Saint-Pierre, who in 1713 laid out a grand plan for peace in the world. Of course, it was a plan based on realistic premises, so this would be a plan for the monarchs to conduct a peace agreement that would enable them immediately to crush any rebellion against their authority. That's why Jean-Jacques Rousseau, a few years later, thought that he was a hopeless apologist. And Rousseau himself said, well, something else should be done, that the state should change, and that democracy and self-determination must be there before anything like peace can be in existence. One of the strong memories I have of the 1990s, you realize already, 1990s, bad. One of the moments of the 1990s in which I participated was the effort to change the rules of the Security Council. What is the Security Council for? To keep peace and security in the world. How is Security Council failing? Well, because it has just some big guys there, but not the right big guys. And anyway, the rules of procedure and everything about it wasn't conducive to anything like peace. It was just conducive to an imperial policy of another kind. So people were very agreed on that. So there was a push towards reforming the Security Council. Cynicism. What about humanitarian law? This piece of law that is the only piece we know of that tells you how to kill with impunity and calls itself humanitarian law. There's a lot in which we can improve ourselves as international lawyers when we, in a truthful way, as as Kant would say, as moral politicians, would speak about peace in ways other than those that will advance the cause of ourselves or our party. And of course, equality. Justice, peace, and equality. What is equality? Equality is not having privileges. Equality is not just, let's raise the bottom a little bit. Equality is also, let's bring the ceiling down. Because equality needs to be seen performed. And it can only be seen performed when the nose of the elephant in the famous Milanovic curve is cut. Before that, we can be speaking of equality in the cynical tones where everybody knows that whatever expectation this creates for us, our experience will never be able to match. So I leave you with this, that there is a lot of strategy and technique in law, which has to be implemented through complex knowledge regimes that are instruments for us and our purposes, which don't bind us, which are open-ended, and in which our truth can also be the general truth. But not only strategy and tactic, but there's a possibility of performing justice, equality, and peace. Law as performance. And I suggest that when the next protest march comes in, and we need to address that protest, let's not talk to the protesters about the pros and cons of investment law. Let's talk to them about justice, peace, and equality, because the only alternative really is this. Thank you.
Martti, thank you so much for a great talk, or I should say performance. That was really, really wonderful. There's a lot to explore further, I think. You have kindly agreed to do a Q&A, so I'm sure there will be many who want to raise a question. Please say your name briefly, and if you can do just not too long a comment, but maybe a real question.
I'm Philip Langbroek from Utrecht University. Last Monday I was in Budapest in Hungary, and there was a small seminar organized by several EU ambassadors, and the subject of the seminar was judicial independence. And what struck me during the seminar, which was public, was that the Hungarians didn't dare to speak up, as if the Iron Curtain was reinstalled again. From my humble perspective, I don't speak Hungarian. I go there from time to time and speak up about judicial organization, judicial independence, that type of values. Do you have any suggestion, other than continuing what I am doing there already, what we can do to support, well, utopian rule of law in Hungary, whereas it is jeopardized by the Hungarian government? Thank you.
Well, so rule of law is of course a really big set of questions, and there are no clear institutional ways in which you address those questions. So we often fail in our imagination. We have an idea, rule of law, that must include X, Y, and Z, because some textbook or some declaration says that that's what it needs to include. But I don't think that that independence and the critical voice of the judiciary is dependent on some specific institutional arrangement. And I support this with a project with which I was involved in at the time when I was working with the Asian Development Bank. This was in the early 2000s. I was a judge at the Administrative Tribunal of the Asian Development Bank, and because there was lots of things that we were doing, one of the things was a study of the rule of law in a number of East Asian countries. And it transpired that if you imagine, this was a study sponsored by the MIT and many of the people in the bank, including one whom I see here, was present in that study. And what came out was that if you think of rule of law, say in India in comparison to Cambodia, or if you think of rule of law in relationship to Cambodia, say to Vietnam or or Laos, that the social context is so different that if you bring an European American set of institutions, judges with a certain jurisdiction, etc., then the outcomes are completely different. Because if that single institution falls in a different context, the context will make it different. So from what I took from that experience was that, well, what law really requires in practice is a lot of imagination, not to be fixated with the idea that a good purpose, such as to have control of government by people reasonably independent from government, that it should operate in precisely this ways, but in other ways. And I realized that in Hungary, for instance, through other sources, I know that the situation is difficult, and the difficulty is exacerbated by the fact that the Orban government is pretty clever in its institutional and legal imagination, so that they can circumscribe various EU activities by taking action which doesn't immediately appear to have certain consequences. But this is a political struggle, and so it's really hard to say to a protagonist in that struggle anything else apart from try to be more imaginative than your adversary and to bind that. So, but this is not something that you didn't know before I told you.
Please.
Thank you for your fantastic speech. And my name is Rolf van der Hoeven from the Institute of Social Studies. One of your final conclusions was making reference to the Branko-Milanovic curve. Look at the redistribution issue, but don't see the redistribution issue as leveling up a bit of the poorest, but actually bringing down the share of the richest. Now, if we look at one of the new covenants in the international arena, the Sustainable Development Goals, goal number 10 is about reducing inequality, but because of political issues and also because of working of conservative forces, the only recommendation on bringing down inequality is lifting up the bottom a bit. There's nothing on redistributing from the top, redistributing from capital to labor. Now my question is, how can human rights lawyers go further than what is internationally agreed now in a covenant like the Sustainable Development Goals on inequality? How should they act to make that goal of reducing inequality stronger than it's worded now in an international covenant?
Well, the question involves a premise with which I would like to argue, and that is that the right people to act here are human rights lawyers. And so I said already, maybe a little provocatively, that to become a human rights lawyer is to shoot yourself in the foot and to incapacitate and marginalize yourself and to imagine a career in institutions that have no power. But I also think that. And so what I've found recently really inspiring is heterodox economic doctrines. So to have economists speak about the economic needs of leveling also from the top down at the same time as from the bottom up. So I don't so much bank on the ability of human rights people to do anything here. They just are usually in a weak position. Their arguments do not translate easily to economic institutional solutions, for instance. And I know nobody is happier to speak the language of human rights than Milton Friedman, and the Friedmanites, because after all, the right of property is the holiest of the human rights in the very long tradition of human rights, if you take John Locke, for instance, as the starting point. So I think human rights in some sense are not helpful. But heterodox economy is a development economy, and when law enters development, for example, it can do things in development that actually lead to the kinds of leveling that we would want to see. It's a strategic instruction. I couldn't tell you which is the exact economic model to be followed, but I would be interested to talk to you about that.
Thank you. I think it's fair to give the floor to a human rights lawyer at this point.
My name is Eduard Nazarski. I have a confession to make. I work with Amnesty International. And I'd be happy to discuss some issues of amnesty at another moment, but what I would like to ask you is, what we see is that in very many countries, authoritarian regimes are taking over, and it's getting very dangerous inside many countries to speak freely, to speak out, or to organize activities. We know change in many societies like Saudi Arabia or Azerbaijan or Turkey or the Philippines, and to mention not very many others, should come from within. But if that's getting that dangerous, what could be any meaningful intervention or help or facilities from outside that country?
Yes. So as was perhaps suggested by my presentation, I'm presently writing a chapter in this forthcoming or maybe posthumous book on the French Revolution. And I'm thinking constantly in terms of how did, because, so there was a mass movement there too, and the celebration of the fall of Bastille was wonderful, and there was a lot of, wine on offer the next day, but 2 days forward the head started to fall, and then it went its own way. And the revolutionaries, of course, wanted to revolutionize the adjoining countries as well. And the 1990s was the liberal euphoria when we thought that we can just institutionalize our own political languages, to which also human rights language belongs in some way. Now that fired back really dramatically, and we are still suffering from the consequences of that firing back. So for my instruction for Europeans is stay away. Whether you carry an amnesty card or whatever card, stay away unless you're specifically invited to be there. And then if you're specifically invited to be there, then talk with people. And don't think that the values that you are promoting necessarily have to come with a particular technical language. The language of rights, for example. Or it could come with many other things. The language of rights, like any language, is, as Paul de Man would say, is a tool of insight, but also a tool of blindness. When the only thing you see when you open the window is rights, then there's a lot of things that you don't see, and a lot of institutional avenues that do not get taken when you imagine the world in those terms. I'm sorry to be so pessimistic and critical of the rights, because many people who share my political intuitions are in the rights camp, and I feel that my task is to turn to them and say, hey, well, let's look again, how much have we achieved, how much these tools that we have enables us to achieve, and wouldn't there be some other tools and some other languages that could make it easier for us to attain the goals that we want to attain?
In the back, Jeff.
Thank you very much for a really riveting talk. You mentioned how international, Jeff Handmaker from the Institute of Social Studies, like my colleague there. You mentioned how international humanitarian law allows one to kill with impunity. Of course, that's the way in which it regulates, or is supposed to regulate quite ineffectively, as we've seen, the rules of war. The other function, of course, is to protect civilians quite inadequately, including, of course, humanitarian workers. But its third function, I think, and certainly as represented by the International Criminal Court, is to end that impunity, at least through the rule of law. Surely this is something that we should be working much more strongly towards, and that it's actually the mobilizing function of law that we need to focus our attention on in making law meaningful and giving it that sense of politics and engaging with those politics within these institutions to give it meaning. Would you agree?
Well, so I think there are these two ways. So one has to be strategically and institutionally very skillful. One needs to enter an institution and see what one can do within that institution. If it does what it's always done and you become like your dad, then you have to leave the institution. But some institutions have more or less leeway of changing, and you can. So I'm not trying to say that one shouldn't work with something like the International Criminal Court or within the ICRC, for instance, in some projects. Some people work in shops and other people drive taxis and others are professors. So why not do that as well? There's nothing particularly evil about that. But the institutional imagination that we have is so poor, and we are unable to see the causal relations that lead to particular institutions in the world. Very often, so the economic is really a very important thing in getting done what we want to do. And the institutions that most directly have to do with managing economic decision making are not populated by people whom I would want them to be there. And so I'm just pushing this agenda, saying, yeah, okay, so you can be in the International Criminal Court, see whether you can actually achieve something, but if not, then don't. So I have to. So I even was in an international institution called the International Law Commission for 5 years, and so in that commission, like some other people in the room, and one of my experiences from that time is when I ask myself, is any one single person in the world affected in any way? Can I trace a single causal line from this draft convention to the present? And I can't do that. So surely that is a problem that we can't do that. And sometimes institutions like International Criminal Court have a better day because they can point out. But again, there it's a mixed message. So some people who are most directly concerned are most critical of this whole institution. And I often feel myself, if international criminal law is spoken of, that the kinds of efforts that the Russell Tribunal, for instance, once upon a time tried, so popular tribunals in which you don't have all the paraphernalia of judge and wigs and prosecutors and thousands upon thousands of pages of documents, that those are as performance. That as performance, those are more efficient and less dangerous, maybe.
The final question. I'm turning to my right, if I'm not overlooking anybody. Yes, okay, please, the final question is yours.
Thank you. Hi, I'm Lucy Turner. Thank you very much for your presentation. I thought it's very interesting. I couldn't help but note your cynicism when you speak about human rights. I was wondering if you extend this to, you spoke about the language of rights generally, and I was wondering if you extend this to things like the UN Declaration of the Rights of Indigenous Persons or the rights of peasants, things like that, which seem to have a different approach than, say, the traditional human rights language of land ownership and things like that. Thank you.
Well, so the language is really important. And when we enter the world with the hope of improving something there, we have a choice of languages. Through which languages do we address that world out there? And the language brings with it a set of institutions. So if you choose your language will be international law, let's say, in general terms. And that empowers you to do some things. It doesn't empower you to make a coronary operation, but it empowers you to do other things. Then nowadays, if you're just a public international lawyer, then you're there's not much that you are. You must become a trade lawyer or a human rights lawyer or an indigenous person's lawyer. And then, whoops, you are in there. And that language then, empowers you in some ways, but it also incapacitates you in many, many other ways. Again, I think that very often when rights activists, either in indigenous field or in other field, imagine themselves as rights activists and think that institutions in which rights activists are powerful are the institutions that should deal with the problem with this indigenous population, then they provide a really narrow way for that indigenous suffering population to improve that situation. Maybe, a budgetary set of arrangements in that community would bring out the solution better. Or maybe the community actually needs better educational facilities that need allocations from the federal budget in some ways. And how do you then operate there? So if you imagine yourself as a rights activist, active in rights institutions, speaking the language of rights, then you are on a very narrow field in which there is not much funds that are available there and not many people and institutions with power with whom you then talk. That's my only concern. I imagine that I would be, if you describe to me the situation of the person whose situation you would want to improve, I would agree that that would be an important thing. But I would not think that some rights-connected language or professional technique would be the appropriate. Maybe it would, but I wouldn't a priori think that. And then, of course, there's this old problem with a lot of human rights activism, that it measures its effectiveness by the amount of material that it produces, which is, of course, international lawyers are like that as well, not least the International Law Commission.
Martti, you leave us with so much to think about, to discuss. The advantage of being here is to look at all your faces, and I see that there is a lot more to explore and to discuss if I look at all of you. But it's wonderful that you've been so attentive, raising so many questions. And now, please join me in thanking Martti for a final time. Thank you so much.